Hello, 안녕하세요, ni hao, kia ora. My name is Tina Huang and I'm a Senior Associate at QueenCityLaw. Today I will be talking about the 3 myths about wills and why you need an enduring power of attorney. This information is correct as of 8th of September 2022 and cannot be used as legal advice. First up, a common misconception is, I don't need a will as I don't own much. Well, do you know if you've got money in the bank, most banks will require a will and a probate before releasing the money to your family. And also, if you don't have much now, if you have life insurance or KiwiSaver, your estate could actually be more than you think. Lastly, I've seen relatively small estates get even smaller through legal fees, from claims from ex-wife, current spouse, the son and the daughter. You could still have a claim without a will, but at least you will have trustees and executors appointed to protect and preserve your assets in the meantime. Next common myth, I already have a will. Well, when did you do it? Because the important thing is, a legal change in your status could mean that your will is automatically revoked. So if you've entered into a new relationship or got a divorce or dissolution or separated from your de facto partner, then your will is unfortunately invalid now. Also, was it before you had children? Because even though your will is technically valid, it probably needs an update to account for guardians and your children. And also, do your family know it exists? Because it's important that they do. The last common myth is, my spouse will just get everything and manage it for me. I don't need a will. Well, firstly, what if you pass away at the same time? I'm sorry, it's a grim thought to have, but it is a possibility. And secondly, what about your children? If they're underage, who will be the legal guardian? Blended families could mean disputes and tension. Perfect families could still mean claims. It is best to pre-plan so that your loved ones are protected and they're saved from the further anguish of having to deal with these potential disputes after your death, which will already be quite painful. Now, 3 myths about enduring power of attorneys. Before I get into the myths, I want to explain that an enduring power of attorney only comes into effect if you become mentally incapable and stops when you die. Your will comes into effect after you die. So, there are 2 types of enduring power of attorneys. One is personal, mostly for your health, and the second is property for your assets. So with all that said, let's get into the common myths about enduring power of attorneys. This first one I've heard a lot is, enduring power of attorneys are for old people. This is a common misconception. It was thought of something you get before you retire, but now due to COVID and current times, everyone should prepare one. This is because you could have something unexpected happen to you, like a car accident, life-threatening illness such as COVID or a stroke. All of these could leave you vulnerable and unable to make important decisions. Of course, if you get dementia, Alzheimer's, Parkinson's and other brain-affecting symptoms, an enduring power of attorney would be required by the health providers. Most rest homes and care facilities now require an enduring power of attorney by a matter of course, and if you already have these signs, it's probably too late to sign one. The next misconception is that an enduring power of attorney is like a power of attorney. Well, an enduring power of attorney is not your ordinary power of attorney, which only has effect when you have mental capacity but are unable to sign for convenience. An ordinary power of attorney is actually being phased out now because COVID has taught us that anyone can sign documents anywhere in the world, and electronic signatures are becoming more and more prevalent. If you have a computer, most banks and parties are now allowing you to sign electronically without seeing the original. And last but importantly, this one is not true. An enduring power of attorney comes into effect after I die. Or actually, your enduring power of attorney stops when you die. You can also cancel it at any time by telling the attorneys while you have mental capacity that you want to revoke your power of attorney. So, this comes into effect when you do not have mental capacity, so it is different from your will. So in conclusion, a will and an enduring power of attorney is not something that you want to think about because you don't want to think about death. However, it is a certainty. You just don't know when it will happen. But when it does, you'll be gone and your loved ones will have to deal with your affairs. So please make it easy on them and take this time to prepare your will and enduring power of attorney. Feel free to contact me or any of our team that can help, and our details should be up below, down, and you can contact us at any time. Thank you very much.